the folks at the NYU Journal of Law and Public Policy for their leadership on this event, as well as the staff of the Birnbaum Women's Leadership Network, who have worked so tirelessly to make this program a reality. We have a star-studded panel to unpack SB 8 and to look ahead at what the future of reproductive rights looks like. I'm delighted to be here to moderate this conversation. My name is Melissa Murray. I am the Frederick I. and Grace Stokes Professor of Law here at NYU, and I also have the privilege of being the faculty director for the Birnbaum Women's Leadership Network. And in that capacity, it is my delight to welcome our fantastic panelists. Our first panelist is Aziza Ahmed, who is a professor of law at the University of California, Irvine. Her scholarship examines the intersection of law, politics, and science in the fields of constitutional law, criminal law, health law, and family law. We are also joined by Malia Aziz, who is an organizer for the Texas Equal Access Fund, and she's also an abortion storyteller with We Testify. Most recently, and relevantly for this conversation, she testified before the House Committee on Oversight and Reform in support of abortion access and against SB 8. We are delighted to welcome back to NYU one of our own alumna, Professor Liz Sepper. Professor Sepper is a professor of law at the University of Texas at Austin. She's a former law clerk to the Honorable Marjorie Rendell of the Third Circuit, and she is a nationally recognized scholar of religious liberty, health law, reproductive justice, and equality. We are also delighted to have Dr. Ghazaleh Moayedi, who's a member of Physicians for Reproductive Health. She's an obstetrician gynecologist with an extensive background in reproductive care. Prior to becoming a physician, Dr. Moayedi worked in abortion care at Whole Women's Health in Austin, Texas, and was on the board of directors for the Lilith Fund. Like Ms. Aziz, she recently testified before the House Committee on Oversight and Reform on the dangerous impact that abortion bans have on her patients in Texas, including the impact of recent Texas Senate Bill 8. And finally, we are joined by Julie Rickelman, who is the litigation director of the Center for Reproductive Rights. You may also know her from her rendering in the Supreme Court drawings because she was the litigator who successfully argued June Medical Services versus Russo in March of 2020, a major abortion rights case before the Supreme Court. In addition to June Medical Services, she has also been involved in other frontline litigation work, such as fighting to keep open the only abortion clinic in Mississippi, challenging abortion bans across the nation, and leading the center's efforts against invasive ultrasound laws. And this work includes developing an innovative legal strategy that exposes how these laws violate the First Amendment rights of patients and providers. So to get started and to set the stage for the conversation, let's basically get our bearings and talk a little bit about what SB 8 does and how it impacts abortion access in Texas. So Professors Ahmed and Sepper, can you give us an overview of SB 8? We know that this is a law that bans abortion at a particular period of time, but can you explain why this law has managed to evade the traditional fate of such laws, which is usually a federal court injunction while its constitutionality is being litigated?
Thank you so much for having this panel. Thank you so much to the organizers. Thank you, Melissa. While we're starting this conversation, I just want to say that I'm one of the many people who was more excited to hear the strict scrutiny analysis of SB 8 than actually listen to the arguments. So yeah, SB 8 passed in Texas. It's a law that is blatantly unconstitutional. It basically bans abortion after fetal cardiac activity, which typically is 6 weeks after a woman's last period. I use all the language that I'm using advisedly. The conservatives call this heartbeat bans. Is whether or not this is actually a heartbeat is very much under question. It's very doubtful. And of course, people like to say a woman is 6 weeks pregnant when a person actually has not been pregnant for 6 weeks when they are pregnant, when they are called or told that they are 6 weeks pregnant. It allows anyone anyone to essentially come after abortion provider who has provided an abortion in that window. It's been referred to as a law that facilitates bounty hunting because of the large penalty on the provider, and that can be won by the person who's bringing the claim against the provider. It's been analogized to the fugitive slave laws, which had a similar dynamic where essentially individuals were empowered to enforce laws. It also opens the door to cases against those people who are, quote unquote, aiding or abetting. So there's been discussion about Uber drivers, about people who, simply aid in the most minor of ways, a woman who's trying to get to a clinic. Now, this is a different kind of law because normally states enforce laws, and typically if a person wants to enjoin a law before it goes into effect, they would essentially sue the state and sue the state official, and they would be able to have the law that is, especially a law like this, that is unconstitutional, enjoined. But in this case, the citizens are enforcers, and so there's a big question on the table, which is, who do you actually sue? You can't possibly sue everyone in the state of Texas or every single person who might bring a case against an abortion provider. And so, how do we actually find the person who we can hold accountable here? One of the questions is, can we sue the courts? Can we sue judges? Can we sue clerks as enforcers? Does this law essentially weaponize the court? Does it essentially make it so that the courts themselves are essentially implementing this law? What are the legal grounds for doing this? Another big question in the SB 8 context is, can states actually create a workaround like this, even separate and apart from the abortion issue? Should this be permissible, that states can essentially evade any sort of federal oversight? I think this is an important issue with really broad implications. It's that you can read about in the NAACP amicus brief, that you can read about in that several people have argued essentially that the reason we have the ability to hold states accountable for essentially violating core constitutional rights is because states do that a lot, and they have done that a lot, and they have especially done that in the context of civil rights laws. So maybe I'll stop there.
Liz, do you want to jump in?
Yeah, I'll add that, and as Mark Aaron argued at the Supreme Court, SB 8 combines the bounty hunter provision with a number of special procedures that favor bounty hunters and make SB 8 unlike other civil litigation in the state of Texas. I mean, as Professor Ahmed said, of course, there's issues around standing, right? You don't have to be injured in order to file a lawsuit. You can be totally unrelated to the person who had the abortion or the doctor who performed it. But there's other procedures as well. There's very little ability to challenge globally the law. There are limitations on who can raise constitutional arguments. There's no issue or claim preclusion. So even if a defendant wins, they lose. They have to keep litigating the same issues in new lawsuits. And even if the law is enjoined, right, the SB 8 provides that if it goes back into effect at any point, lawsuits can be brought for abortions provided during that period that were legal under law that was enforced in Texas. So it's quite different from other standard civil litigation, even notwithstanding the bounty hunter provision.
So can I just sort of interject to ask, leaving aside the procedural mechanism, which is both unusual and rather devilish in its means of avoiding a federal court injunction, would this law be struck down as unconstitutional if we were ever to reach the merits of the case?
Yes. I mean, yeah, no, thank you, Professor Murray. I think we have to stay focused on that. This law is blatantly unconstitutional. Casey v. Planned Parenthood very clearly said you cannot ban a pre-viability abortion. This is way pre-viability. We're not even in any borderlands here of life. And yeah, no, this is an unconstitutional law, and it's an act by the state of Texas to basically say to the Supreme Court, we're going to do what we want to do, and this is how we're going to do it.
Okay, go ahead, Professor.
Oh,
Sutcliffe.
and I know, we're going to hear a lot more about how the law is operating in practice, and I'm excited to learn more and hear more. But I mean, in practice, right, let's be realists about this, it's operating as a ban on abortions after 6 weeks. And Roe v. Wade, to my mind, doesn't stand for much, right? It's sort of a rhetorical marker we use to talk about abortion. But if it stands for anything, it means no pre-viability bans. So that's clearly been violated in the state of Texas. There's no argument that abortions just past embryonic cardiac activity are after viability.
Okay, so we have a law that, according to Justice Sonia Sotomayor, is flagrantly unconstitutional, and you all seem to agree with that. Dr. Moietti and Malia, what is the current state of abortion access in Texas after September 1st, when this law went into effect and when the United States Supreme Court refused to intervene to issue an injunction to prevent it from going into effect? And so maybe, Malia, could you speak to the impact on pregnant people in Texas? And maybe Dr. Moietti, could you speak to the chilling effect it may have had on physicians providing abortion care?
Yeah, absolutely. So, to keep it real, shit is really, really bad here in Texas. Things are terrible. This is a horrendous law and people are really suffering. The reality is that very few abortions are happening in Texas right now because of SB 8. I'd say, and Dr. Moietti, correct me if I'm wrong, but I'd say 90% of people are having to go out of state to have their abortion. That is significant, and it should not be like this. SB 8 has been in effect for 2.5 months, and I sit here and I'm still shocked that this is our reality, but it is. When initially there were talks of this and we heard about this, some of us laughed it off because we never thought this would become our reality. And then it did. And it's absolutely devastating and heartbreaking to see people feel so desperate and helpless and hurt and not know what to do because abortion is healthcare. And people are not getting access to the healthcare that they need. It is so wrong. People in Texas have fewer rights than across the country. And as an abortion storyteller and someone who's had an abortion, I had to travel out of state for my abortion. And it was bad enough in Texas before SB 8. Now it feels impossible. But as someone who's traveled out of state, TFUN, we're a grassroots organization and we serve the North Texas area, but we also serve the communities that are most impacted. And even before SB 8, most of our clients, low income, people of color, half of them already parents, and having to travel out of state adds additional barriers to what was already difficult in Texas before SB 8. You have additional logistical barriers if you're having to travel out of state, not to mention it costs so much more. People will throw out a conservative amount along the lines of, oh, we're having to pay $500 to $1,000 more. But based on my personal experience of having to travel to Colorado Springs to have my abortion many, many years ago, so nearly 8 years ago, I had to pay $2,000 because it's not just the procedure that you're paying for. If you're flying or traveling, either you're paying more for gas, you're paying more for flight, you're having to pay for hotel or somewhere to stay because of the 24-hour wait period or the mandatory ultrasound, which is invasive, disgusting, and ridiculous. And I had to go through that, and it was very traumatic. But all of these other restrictions, you're having to pay more money. For parents, it's even harder because, well, what do you do with your children? Children can't necessarily go with you to a clinic. And if you're trying to have an abortion because you're struggling to make ends meet, well, now you have to figure out childcare so you can travel to another state and have an abortion. So just to paint you a little picture, shit is really bad. And I don't know how else to say this. Things are terrible in Texas right now. And something needs to change. And we need to get out of this horrendous, horrendous situation that we're all stuck in right now.
Are you seeing an uptick in requests from your abortion fund and other abortion funds in Texas?
I think the best way to say this is because we know that Texas isn't performing, clinics here are not performing abortions after 6 weeks. So there's an uptick in people needing to go out of state to access their procedure. but people are less likely to ask for help because, unfortunately, because of the misinformation, a lot of people think abortion is just illegal, period. And if they ask for help, they're going to get in trouble, or their family or friends are going to get in trouble. So because of the misinformation, people are also less likely to reach out and ask for help, if that makes sense.
Dr. Moietti, what's the climate like for providers and staff at clinics? I understand that most of the providers, as part of their licensing requirements, have to disclose if they are subject to lawsuits, including a lawsuit on the basis of SB 8. Is that chilling the prospect of abortion provision or any kind of reproductive care in Texas at this point?
Yeah, thank you so much, Professor Murray. That's a great point. So, something that people don't think about is that a physician who is licensed has to report any sort of legal action, not only to the state that they're licensed in, but any insurance company that they're insured by, any hospital that they have privileges in. And it's unclear if this sort of civil litigation is something that we have to report or not. The Texas Medical Board seems to say that they're not going to come after us, but that remains to be seen, right? They are appointed by the governor. And the effect has been chilling. I have colleagues that are not practicing intentionally in Texas right now out of fear of litigation. I have not been able to practice in Texas just because of the decreased amount of need in our state currently. And so I am personally traveling to Oklahoma to provide care. I'm in an office in Oklahoma right now. And, I have friends that are traveling to Louisiana to provide care for people on the coast, and people that are traveling to New Mexico to provide care for Texans as well. So physicians themselves are seeing that they're needing to travel out. We're all expanding our licenses in preparation for maybe more than a year of this. And the effect is certainly, I have a deep fear about what will happen with our workforce long-term, the longer that this bill stays in effect. Prior to this bill even being enacted, we were seeing a high amount of turnover at clinics from staff because people weren't sure if they were going to have a job anymore. And right now we've been able to sustain at least staff in payments and keeping them employed, but it's unclear if we get into 6 months, a year, 2 years, how we're going to actually maintain our workforce. The abortion care workforce is a highly skilled workforce. You can't just hire someone off the street to come help you in an abortion clinic. They have to be highly trained, highly compassionate. Like, there is a really unique skill set to work in abortion care, and that is a very valuable workforce. And so losing them to other areas of healthcare or other states is going to have decades of impact on our state.
Thank you. So Julie, let's sort of talk about what the point of SB 8 was and sort of how it fits in with the broader landscape of pre-SB 8 litigation. So as you know, this is not the first abortion restriction that Texas has passed. A few years ago, there were 2 abortion restrictions, one that required physicians to have admitting privileges at area hospitals, and another that required abortion clinics to be outfitted as ambulatory surgical centers. The first, the admitting privileges law, went into effect while its constitutionality was being litigated, whereas the surgical center requirements were enjoined until their constitutionality could be determined. But even though one of those provisions was enjoined, with the other one going into effect, we actually saw a marked shuttering of abortion clinics in Texas. I think Texas went from having roughly 40 clinics to having 19. And interestingly, although both of those laws were determined to be unconstitutional in 2016's Whole Women's Health versus Hellerstedt, we did not see the rebounding of those abortion clinics in the aftermath of that decision. We did not see the clinics that had shuttered go back into business. And it seems that SB 8 and the drafters of SB 8 recognized that and realized that if a law can just go into effect, it can have this chilling effect that is long lasting, even if the law is ultimately pronounced unconstitutional. So with that in mind, what are you all doing at the center to maintain abortion access in Texas, to keep clinics open if you can, and to keep the broader network of abortion providers open and in business during this difficult time?
So you just laid out exactly what the goal of this law was, which is to shut down clinics for as long as possible, with the understanding that once clinics shut down, it is very difficult for them to reopen for all the reasons that folks just talked about. So when the clinics shut down because of the admitting privileges restriction that Texas passed. They were shut down for about a year and a half before we won at the Supreme Court. We got that law struck down as unconstitutional, like you said, but unfortunately, the clinics that had shut in that year and a half have almost to the one have not reopened. I think perhaps one was able to reopen. They've all stayed closed. So Texas was down to just 20 clinics. It was reduced by half, like you said. And that is absolutely the goal. Texas, for over a decade now, has been trying to either make abortion completely illegal or make it impossible to obtain through every means possible. And shutting down clinics and trying to keep them shut is, of course, one way to do that, and a way to do that is unfortunately very successful. In terms of what we can do to keep clinics open, both in Texas and in the rest of the country, really the honest answer is it's very hard, and there's not really much we can do. So clinics that are nonprofits, there's a handful of clinics that are nonprofits. Folks can donate funds to them. They can fundraise. People who are interested in keeping access available can make donations. Foundations can make donations. But for a regular medical practice, most of those medical practices, like other types of medical practices, are for profit. They're offering a service that they get paid for. And if they don't have people who can come there for care week after week, month after month, year after year, they're going to shut down. And so it is really scary. And, it has been 2.5 months that the ban has been in effect now. That is, every one of those days is just a tragedy for people who need access to abortion. It's a really long time. And I am really concerned about whether the clinics are going to be able to stay open. And so we're going to continue doing everything that we can as a legal organization. But I do want to be honest and say, as a legal organization, there's not that much we can do to keep clinics open. But Texas keeps passing abortion restrictions. Just so folks know, they passed another set of restrictions on access to medication abortion, even after they passed SB 8. And so they're not stopping. They're continuing to pass every restriction they can. And meanwhile, we have been challenging restrictions in surrounding states. So for instance, Oklahoma, which has seen a lot of Texas patients come since SB 8 went into effect. All of the surrounding states have, but Oklahoma in particular, they just passed a set of restrictions, including 2 different abortion bans, not just one abortion ban, but 2 different abortion bans. And we've gone to court and we challenged those. And thankfully, we were able to get a preliminary injunction. So those laws are not in effect, because if they had gone into effect, it's just a ripples across the country, making access harder and harder. So we're doing everything that we can as a legal organization. We're not going to stop fighting. We took it to the Supreme Court. We're filing challenges to the restrictions in other states. But at the end of the day, it is deeply concerning that essentially the state of Texas has taken away a constitutional right for 2.5 months, and the courts have not stepped in to stop that.
It's almost like you're playing reproductive rights whack-a-mole. As soon as a threat emerges, you bat it down, but another threat emerges again in some other place to deal with.
That's absolutely right. And that's one of the reasons, I know all of you are familiar with it, but that's one of the reasons why we've been supporting the Women's Health Protection Act, which would be statutory protection for abortion access around the country, in addition to constitutional protection, or if constitutional protection was ever lost. But again, that is critical. It's an important legal change that we need. But right now, in terms of helping clinics in Texas right now, it is very scary. And every day that the law remains in effect, I think the clinics are really in jeopardy.
Let's talk about the Women's Health Protection Act a little bit later. So just tie a knot in your mental handkerchiefs around that for a bit. Let's talk a little bit about what's happening. So we saw some unprecedented responses to SB 8. So the law went into effect on September 1st. In the evening on September 1st, the Supreme Court declined to enjoin that law, allowing it to continue to be in effect. And then we saw in the wake of that decision, a number of suits brought by providers against various state officials. So Whole Women's Health versus Jackson is that provider's suit. And then again, highly unorthodox, the United States government, the Department of Justice, intervening on behalf of the country against Texas. So United States versus Texas. So let's maybe take the last one first. Julie, can you explain the DOJ's lawsuit, the theory of the case, and basically what the argument was when it was litigated on November 1st?
Sure, I will do my best. It involves terms like intergovernmental immunity, which are not my area of expertise. I'm a reproductive rights litigator, but if I can sum it up, and the professors on this call can correct me if I'm wrong, but what the United States, thank you, what the United States has said is two things. First, it has said we actually have obligations through a number of our healthcare programs to make abortion access available to people. And you're directly interfering with our ability to do that, state of Texas. So first, we're suing you for that reason, because you've made it impossible for us to fulfill our responsibilities in some of our programs. But the second argument they made, which, as Chief Justice Roberts noted during the argument, is a pretty broad argument, is that they have the ability to go into court and file a lawsuit to say to a state, you are violating the US Constitution, and it is our job to make sure that the federal law is the law of the land under the Supremacy Clause, and so we're going to sue you because you are flagrantly violating that law. And what the argument, I think, was really focusing on for the DOJ's case, as opposed to our case, because the center is litigating that case, was really, that is a broad claim. And what is the limiting principle? When then can't the federal government go into court to say that what a state doing is unconstitutional? And the Solicitor General, who gave an incredible argument, pointed out that this law is unprecedented. There is nothing like it. And if they can't go in to block a law like this, when could they go in? And what she was saying there was that, this law, not only does it flagrantly violate the Constitution by banning abortion way before viability, but it is designed to make it impossible for anyone to challenge it in federal court. So it's both of those things. It's the fact that it's clearly unconstitutional and was designed to be impossible to challenge in federal court. That is what made the United States step in, and that's why it should be able to step in this case. But she got some pushback around that point, including from Justice Alito, who said, are you really making an argument for a rule for a case of one, that you're only going to do this in this one case and that you're not going to do it in other cases? So, that's sort of where I think the issues in that lawsuit were playing out, how they were playing out.
When the court heard this argument on November 1st, it was purely on this procedural jurisdictional question: should the United States even be in court suing the sovereign state of Texas? So not a substantive question about the constitutionality of SB 8, purely a procedural question of, can we even hear this case, for all of the reasons that you suggest. It's also worth noting that likely the last time the United States government intervened in such a way to make such an argument was post 1954, when Southern states were dragging their feet about desegregation in the wake of Brown. And the court, of course, in Cooper versus Aaron, suggested that any sort of non-compliance with Supreme Court precedents interpreting the Constitution was tantamount to subversion of the Constitution itself. So again, a similar thread being woven here. But you also noted that there's a different kind of procedural question at play in the lawsuit that the center brought against the various state officials. So can you explain why the abortion providers are suing people like Texas state court judges, Texas county clerks, and the head of the Texas Right to Life group?
Yes. So the reason that the DOJ brought its suit was because the Fifth Circuit said that we couldn't bring our suit, which had come first, because we were barred by sovereign immunity. So, DOJ came in because the Department of Justice can directly sue the state of Texas. There is no sovereign immunity problem. So the reason that the Fifth Circuit said we have a sovereign immunity problem goes back to how this law was designed. So again, this law was designed to ban a constitutional right and then delegate responsibility for enforcing that ban to the general public, to anyone at all, as we discussed at the beginning. And so we were not able to go in and sue the normal state officials that we would sue who have, clear enforcement authority around an abortion restriction. We sued other individuals. So for instance, we sued people who said they wanted to be able to bring lawsuits under SB 8. They wanted to be able to go to court and sue Texas abortion providers. That's why we sued the head of Texas Right to Life. We also sued state court judges and their clerks of court because they, under the scheme that Texas has created, they end up actually being the enforcers of this law. So by docketing the lawsuits and allowing the lawsuits to proceed and making Texas abortion providers essentially permanent defendants for all the reasons we heard, because they can be sued again and again and again. There's no finality. They were really the enforcers of this law. And that's not, that argument has been made before. It, you know, in the Shelley versus Kramer case, the court talked about the fact that in a civil case like this, it is really the courts that are enforcing the law. And so we had that series of defendants in the case because that is how Texas designed the law. It was trying to make it difficult for us to sue the usual state officials.
By virtue of having to actually process these lawsuits, the state is actually involved in its enforcement, despite the delegation of the direct enforcement to private individuals.
That's exactly right. And at the oral argument, you know, it seemed that different justices had different views on what potential defendants seemed to be maybe the most promising. And so I think the court clerks, there seemed some support for that. And then a couple of the justices also suggested that actually we could sue the attorney general and that would have been okay in this case, because really what, again, Texas has done is made private people private attorney generals. It's delegated his enforcement authority to the public at large. So really we could have also sued him. So it's unclear which defendant the court will think is the best one.
Right. So just one more beat on this boring legal stuff. Professors Ahmed and Sepper, you saw the oral arguments. Reading the tea leaves, what do you think is going to happen here? Professor Ahmed, what do you think?
Well, I think that, you know, it's difficult to say. I felt when I was listening to the arguments that the federal government made a really compelling case for all the reasons that we've discussed already. You know, this is going to create a lot of legal problems, not just the sort of big question, sort of resting or related to the big question of can the federal government essentially enforce constitutional laws, but you know, just the very fact that some of the programs that they might be funding in Texas or people that they've employed in Texas to do work for the federal government could now essentially be subject to lawsuits is a huge problem for implementing federally funded programs at the state level. In terms of SB8, in terms of the case that the center is bringing and the case for the providers, I do feel optimistic that the law might be struck down, or that, you know, will at least be halted for a while. But I wonder if the rationales for that won't be because of a deep concern on the part of our very conservative Supreme Court for women's access to abortion, and more about these many other procedural issues that have just been outlined. You know, the very concern that we can't actually have a legal system in which states can essentially just abdicate any responsibility to fulfilling constitutional rights that have been defined by the federal government and the Supreme Court. So it might not be about, you know, people who need abortions, and it might be about this kind of trickier federal state issue.
So basically allowing one or both of the lawsuits to go forward, and probably the provider's lawsuit is the more likely candidate, is really going to be about the court's own legitimacy more so than their interest in preserving women's reproductive rights.
Exactly. And I think a lot of what we're going to see over these abortion cases, even as, you know, we'll talk about Dobbs later, but, you know, as we look at Dobbs, it will be about the Supreme Court's legitimacy. You know, how is this court going to be viewed in 50 years? How is it related to, you know, the public and what the public wants and what activists are asking for on both sides, and the relationship to the court, to those activists, the complicated relationship. So yes, absolutely, about the legitimacy of the court.
What do you think, Professor Sepper? Do you agree that it looks promising, but perhaps a Pyrrhic victory long term?
Yeah, I think it looks promising, but on the other hand, you know, I think near 100% of legal scholars would have said that on August 31st, the Supreme Court was going to preserve its legitimacy, its power, not allow states to mess with the power of the federal courts. And here we are. I mean, maybe the ground has shifted under the Supreme Court, I should say. Yeah, and I thought we had very good signals in oral argument, and surprising signals. I think actually Mark Herron was kind of surprised by the tenor of Justice Barrett's quite sympathetic questions to him during oral argument. But, you know, there were plenty of, I'm not a prognosticator. I don't like to read tea leaves from the court. There were lots of people who said, oh, the court's going to tell us by the end of the week, right? It's been something like 16, 17 days. The court is going to do like a 3-year-old, whatever it wants to do, whenever it wants to do it. And so, you know, time is lost care, it's lost opportunities. And so for now, I just see it as a loss. I mean, every week that passes is a loss for people in Texas.
Okay. The litigation is just one response to the impact of SB 8. Malia, what are you seeing on the ground? What's sort of the grassroots organizing against SB 8 that you're seeing in Texas?
So for TFUN, we've done a couple of things, and we're a grassroots organization, so we do a lot of advocacy on the ground. And with SB 8, we actually work with partner organizations. And you know, as you had read in your description, I was a part of the DC delegation to Texas, where we had a Bands Off Our Bodies demonstration, which was wonderful. We had many different storytellers tell their stories outside the Supreme Court. We testified before Congress alongside you and Dr. Moietti, which I think was very powerful and impactful. We also, you know, it's obviously very important to advocate, and there are legal proceedings in court cases, but we also, with our coalition, the Rape Power Coalition, we had organized a community healing event it was called an abortion ban fire. So we've done things along those lines as well. A lot of it is we tell people, you know, we did a teach-in recently, we educate people on what SB 8 is, because unless you are already involved in this movement, as I told you, a lot of people already think abortion is illegal. Just, you know, people read the news, people read the headlines, people don't really fully understand what SB 8 is, and then people are afraid to ask for help because they already think that abortion is illegal. So I think education is a huge component, and trying to get out there that abortion is still very much legal in the state of Texas. It's just a lot harder to access, but that doesn't mean there aren't any options. There's a lot of confusion around what SB 8 is. I mean, I'm still a little confused sometimes when it comes to what exactly does this mean, which is why it's very helpful when lawyers actually explain what this means. But I feel like even between, I think this was the intention. The intention was SB 8 was going to be very complicated and intentionally confusing. So I think we're all just trying to figure out how to navigate. We're trying to educate and inform people. We're trying to accurately tell people what their options are, what they can do. And we're trying to break down barriers to abortion access whenever we can.
I should also note one of our fantastic sponsors, If, When, How, formerly known as Law Students for Reproductive Justice, has been right in the grassroots doing work to provide teach-ins, to explain, and also to organize law students around these issues over the last couple of months. So we are really grateful for their support today and the work that they're doing across the country. Dr. Moietti, in addition to grassroots organizing, you know, that work is so important for simply dispelling the misinformation that may exist. But can you speak to the particular communities who are likely to be impacted, not just by this law, but the confusion that it is sown on the ground?
Yeah, so, you know, this is an abortion ban, clearly, but it is also I don't have a cute term for it. It is a ban that impacts all of pregnancy care. So some of the communities, as far as, you know, the work that I do, I provide birth care and abortion care, that are being impacted are just pregnant people with desired pregnancies that are suffering pregnancy complications. So across the state, we are seeing hospitals enforce policies that, you know, seem to be a compliance with SB 8, but actually have no grounding in what the Texas Health and Safety Code says about abortion. So we're seeing hospitals tell providers that they can't intervene in a pre-viable rupture of membranes or preterm delivery, something where medically the intervention is immediate abortion to prevent death. But hospitals are telling providers to wait until the patient is septic or wait until hemorrhage has ensued so that they're in compliance. The reality is that a miscarriage and a pre-viable delivery are not an induced abortion, and they're not covered by SB 8. But that is right, the very intent of this law, to sow confusion and misunderstanding. And so what I'm seeing across the state from my colleagues is calls every day about like, our hospital's saying we have to wait for an infection. Is that what we have to do? And I'm like, no, but also that's not going to save you from getting sued. And that I think is also a really important concept for people to understand. It actually doesn't matter if we're complying or not. That doesn't prevent us from being sued, because the lawsuit is also about intent. It doesn't matter if I do anything. I can just intend to do it. And I'm going to tell y'all I intend to do it. So there we go, right? That it's just about your thought around it. And so we aren't actually safe in any way from lawsuits, except from the fact that they're never going to sue us, actually. It's really about just providing care at the standard of care. But that confusion has been really dramatic. Just yesterday, I took care of someone here in Oklahoma who is from my community in Dallas. And one of my partners at the hospital referred them to me because they had a lethal fetal diagnosis, but that continued to have a heartbeat. This pregnancy is not going to be able to live. And so the patient was referred to me for care, but in Oklahoma, we have an over 1 month waiting list at this point for an appointment. I was able to double book her and add her onto my clinic schedule, but that was still a 3-week wait, 2-week wait. And by the time she did, I saw her and there were no heart tones anymore either. So she waited, made the trip, came all the way up just to find out that it was, a fetal demise that could have been taken care of. And so this scenario is happening over and over and over again across our state. In addition, we already know at organizations like T-Fund, which I'm on the board of as well, that most of our clients are people of color. Most of our clients live in poverty. And so those are the people most impacted by this law too. I am seeing a huge increase in the number of people coming to Oklahoma, but what I'm really fearful of are the people that can't make it. There are many people that have never left their towns along the coast and along the border, and they're not going to be able to make it out of state now either. Many people might not realize that along the Texas-Mexico border, not the US-Canada border, that there are internal border checkpoints that are 50 to 100 miles within the state. So if you live in the borderland community and you're undocumented, you actually can't leave the borderland community because of these checkpoints as well. So undocumented patients are also being severely impacted. Just another point I wanted to bring up is that the federal cases are not our only litigation right now ongoing as well. We also have several state cases that are somewhat of a glimmer of hope for us as well. And the important piece in those cases is that they are not necessarily challenging the abortion component of this bill. They're actually challenging all the other parts of this bill that are unconstitutional to the state constitution, removing access to free courts, changing standing by the legislator. I never get that word right. I'm a doctor. But right, all those pieces are extremely dangerous to remain in case law in Texas. And even if we win this federal case, if those things remain on the books, next session, they can pass a 15-week ban and use all of these same rules and leave it, right? This is also not our first pre-viability ban in Texas. Part of the omnibus bill was a pre-viability ban as well that moved our state limit from 24 weeks to 20 weeks. That was never challenged. So we have an ongoing pre-viability ban here in our state, and this would be our second pre-viability ban.
I just wanted to jump here on a point about hospitals and the broader limitations of reproductive health care. I think that, abortion has been stigmatized, it's been marginalized, it's been put to the edges of healthcare. So it requires extreme dedication. But what we're seeing from hospitals in particular, and I know many of the people on the call here are lawyers, so I want to bring this up. We are the ones to blame. It is not the Texas legislature. There are people in general counsel's office at hospitals who are making a weak and cowardly choice to interpret SB 8 in ways that the terms do not support, so that doctors are getting they're getting confusion over what the law bars and allows. They think they can't manage miscarriages. They think that they can't help people even below 6 weeks sometimes, right? And so that's really on us. It's on our profession. And we should be calling out our peers in the hospital general counsel's office, because this is a conscious decision they're making that makes the impact of SB 8 much broader.
It's a risk mitigation strategy, essentially.
Could I just add to that? Just exactly what you said, Professor Murray, that this is, I mean, it's like a cost benefit with people's lives, with women's lives just hanging there. You know, they're basically saying we're going to mitigate the costs of being sued by potentially costing this person her life or her health. And that really struck me when Dr. Moeidi was talking.
Yeah, I think that's the most egregious part, is that what we're seeing with hospitals is that their duty is to the community, whether that's ethically or actually from their tax benefits, right? That they are duty bound to us in our community, but they're putting their own financial perceived risk over their duty to our communities. And I had another point, I forgot.
I'm sure we'll come back to it. Let's switch lanes slightly. So SB 8 is just one of the pending abortion cases at the Supreme Court this term. The court's term was already slated to be something of a barn burner, with cases concerning gun rights on the docket, cases concerning religious liberty and the prospect of school vouchers on the docket. And then there was also a case challenging Mississippi HB 1510, which prohibits abortion at 15 weeks. This is also pending before the court in a challenge called Dobbs versus Jackson Women's Health Organization. So Professor Ahmed and Professor Sepper, can you give us a brief overview of the Dobbs case? So for example, Professor Sepper, can you just tell us what this case is about? What are the facts and where are we in this litigation?
Yeah, so this case is fully before the court on the issue of the constitutionality of a ban on abortion at 15 weeks or later from the state of Mississippi. So it is a pre-viability ban. It is not as early as the one that we saw in Texas. But the Supreme Court, had a number of options before it. It could have chosen not to grant cert, which would have probably been the expectation, but it reached out to grant cert.
So can I ask about that, Professor Sepper? Yeah. The reason why it would not grant cert is that typically the court does not grant cert in cases where the constitutional question is already settled, and ostensibly the constitutional question is settled here because Roe and Casey prohibit states from banning abortion before viability.
Yes, so, right, we've seen lots of pre-viability abortion bans. We've seen even very reluctant courts of appeals say, you know what, the law is clear here. We have to strike down these bans. Instead, the Supreme Court has granted cert on a wide-ranging question, which is whether all pre-viability abortion bans are unconstitutional. And the state of Mississippi sort of pivoted in their cert petition. They had said, maybe abortion providers don't have standing. Maybe this is about fetal pain as a possible line separating constitutional from unconstitutional bans. But having won the grant of cert on this wide question, they're arguing that Roe v. Wade shouldn't be in existence anymore, should be overturned quite explicitly by the court.
So Professor Ahmed, Professor Sepper just mentioned that Mississippi has done something of a complete about face and sort of its request to the court. So when it first filed its petition for certiorari in 2019, its ask of the court was actually quite modest, to decide the sort of narrow question of what viability meant and the court's extant jurisprudence about abortion. But then when it's filed its first brief before the court a couple of months ago, it had taken a more aggressive and assertive posture, explicitly inviting the court to overrule both Roe and Casey. What explains the shift?
Wow. Well, I think the shift is explained by the fact that the court has increasingly become more conservative, that they can feel more confident with the fact that they have an opportunity here. They're seizing the opportunity of a very conservative court to essentially try to overturn Roe, overturn Casey. But, if you look at the amicus briefs, also overturn Obergefell, also sort of undermine all the cases that have essentially developed a right to privacy over time, or come from sort of been grounded in a right to privacy. And so they're seizing the opportunity. They're saying, here's our chance. We have a court that's sympathetic to our very conservative plan. It's fascinating because, of course, for the last 20 or so years, many legal commentators have pointed out that the anti-choice movement has essentially tried to take an incrementalist approach. They've tried to say, oh, okay, well, this is actually about women's health. It's actually that we care about women. That's why we need all these extra regulations. We're trying to make it safe, but here they've sort of let all that fall to the wayside, and they're saying we're going for it. We're going to go for overturning Roe. We're going to go for overturning Casey. And guess what? We didn't care. We don't care what this does to the women in our path, to the people in our path, to accomplish this goal. We're going for it.
So it's worth noting here that the amicus brief that you referenced, the one that not only encourages the court to overrule Casey and Roe, but also invites them to go further to overrule Griswold, Obergefell, Lawrence versus Texas, maybe even Loving versus Virginia, although it notes that there may be a statutory right to interracial marriage if there isn't a constitutional one. That brief was written by none other than Jonathan Mitchell, who is the mastermind behind Texas SB 8 and the person who devised this unusual procedural mechanism that allowed SB 8 to avoid being enjoined by a federal court in the first instance. So these things are all linked, I mean to say. Julie Rickleman, the Center for Reproductive Rights is kind of in the pole position for litigating this challenge and will be there on December 1st when Dobbs is argued before the court. How is the center preparing for what is essentially a kind of galvanizing moment in the landscape of reproductive rights?
Good question. I'm going to be arguing the case. So,
surprise!
We are, of course, doing everything we can possibly do to prepare and do the best possible job, including a series of moots to get me into the best possible shape for the argument. But I think it's hard to really, it feels surreal, to be honest, to be defending Roe versus Wade nearly 50 years later. And I think it is, to follow up on some of the comments that have been made, it really is telling that we started out with a cert petition that was just looking at existing law and asking the question of whether under existing law you can ban abortion before viability. And of course, the answer to that is no, you can't. The existing law is crystal clear. And now it's become a question of, well, can you just find that there's no right to abortion at all in the Constitution and that states can ban abortion at any point in pregnancy? And so, everything is on the line. There's about half of the states in the country have said that they want to ban abortion. They either have pre-existing bans, they have something called a trigger ban, which is a law designed to spring into effect if Roe is ever overturned. There are bans that we have blocked, that the litigators have blocked years ago under existing law that, again, they could try and put back into effect. So it's just tremendous pressure to do everything we can to convince the court that it should not go back on 50 years of law. And that there's really no reason to do that because there's really been nothing presented in Mississippi's brief. It is a request to overrule Roe, but it is really a request to overrule Roe with the hope that the current court just disagrees with it. I think the state of Mississippi even argues that no factual changes are even necessary. The court can simply decide it disagrees and it should overrule. And as we all know, that's not how the rule of law works. It's not how stare decisis works. And I think one of the things that's really important, it's a little bit of a legal wonky point, but I think it'll be important for the court, is that the court already looked at all of these issues 30 years ago in Casey, and every single argument Mississippi makes now, Pennsylvania and the Solicitor General made 30 years ago in Casey, and the court looked at it very carefully and rejected it. So the question is not even, should you overrule Roe, but should you overrule Casey's stare decisis analysis saying that Roe needs to be preserved, that the viability line needs to be preserved. So whether you call it precedent or unprecedented or super precedent or however one wants to put it, these are questions the court has looked at extremely carefully before. It's found no reason to overrule Roe, and Mississippi has come forward with nothing to suggest that 30 years later those arguments are any stronger.
And this will be your second time at the lectern before the court. It should be noted that by itself is worth mentioning, since there are actually a very small cadre of women who are repeat players as Supreme Court advocates.
Yes,
right.
My second time.
We'll be looking for you and rooting and wishing you well on that day. So I hate prognosticating about the court, but this seems to be a place where some prognostication would be good. So Professors Ahmed and Sepper, what are you looking for in this oral argument? And what do you think the court is likely to do with this case? And how will it impact what is happening in Texas and SB 8?
Yeah, I usually think the justices don't show their hands so much in oral argument. I think they did in the SB 8 oral argument, though it could be wrong, right? What am I listening for? You know, I think it'll be interesting to see what questions Chief Justice Roberts adopts, because he is going to be trying to bring some of his fellow conservatives along on perhaps a quote unquote more moderate track, which is to say not moderate at all. I think there's, with apologies to Julie, but I think there's almost no chance that Mississippi is going to lose at the court. For someone who says she doesn't predict things, right? I would be astonished. One thing that I would like to listen to, because I find it a particularly jaw-droppingly stupid argument, is whether the Supreme Court justices bring up Europe as the model, as though Mississippi were just like Europe, which some countries, European countries, vary enormously on access to abortion. But the idea is that many European countries ban abortion except for health or life after 15 weeks or 12 weeks or so on. And so there has been a line that's been running in the media by some commentators and also in some briefs that if Mississippi wins, it's just like Europe. There's no difference between Mississippi and Germany then in terms of abortion access.
I think Mississippi has double the maternal mortality rate of Germany, but right.
Among many other things, you know, universal access to insurance in one and not so much in the other, for example, yeah.
But even the direct comparisons are wrong. At some point, I just think a lot of folks have really gotten some of that data wrong. So if we have time, I would love to set the record straight.
Well, it's interesting too how, you know, Americans and the Supreme Court can be so nationalistic and so superior when it comes to only, you know, sort of the importance of US law in thinking through any regulation. But here, suddenly Europe becomes the example, it becomes the standard we should all be striving for. And on what grounds, you know, it's pretty amazing.
So there may be basically two different modes. From what I hear you saying, Professor Sepper, there is the maximalist path, which would be to actually overrule Roe and Casey and just kick it back to the states. The trigger laws will go into effect. And then there's perhaps this more minimalist compromise route that will likely be helmed by the Chief Justice, hopefully with one of his conservative justices, conservative colleagues with him. And that more minimalist approach is to uphold the Mississippi law, but perhaps eliminate viability as a salient marker in the court's jurisprudence, which I think would then send a lot of litigation back to the lower federal courts to determine whether a 12-week ban is okay, or a 10-week ban, or in the case of SB 8, a 6-week ban. And, you know, and what it's worth noting that one of the things that SB 8 actually does in reflecting on Dobbs is that it makes the Mississippi ban in Dobbs look more moderate, certainly more moderate than it did a year ago. It seems more like a compromise measure. Malia and Dr. Maietti, what would that kind of confusion in terms of litigation at the lower federal courts in terms of what is permissible after a potential minimalist decision in Dobbs, what does that look like for the communities that you serve?
You know, I'll say that anytime an abortion ban is discussed, that we see an immediate impact in our patients and the people we serve. And the example that I give is that not this session, but the session before here in Texas, a representative from Arlington introduced a bill to give essentially the death penalty to people that seek abortion care and to the physicians that provide it. And it was, you know, too radical at the time, but we saw this session that actually many people were calling for it. So too radical at the time, but not so much now. And even though I think it only got like one kind of day in the ledge where they talked about it. That week, I had a patient that came in and said, "Doc, I know I'm going to get the death penalty for this, but I still need this abortion." And so that, whether or not people follow the legal stuff as much as you guys do or us, they hear the little clips, right? And they especially hear the clips from the really out there sources, or whatever their auntie is saying on Facebook. And so that is what really comes through in the ether, and it really confuses people. And, you know, it is such, I think that story is so impactful because it really shows that, like, it doesn't matter what the law is, that people need this care and they're going to do whatever it takes to get it.
Leo, what are you seeing, or what will you likely see if this goes back to the lower federal courts as they try to figure out what is now permissible if there is a change in the legal landscape?
I'm going to echo what Dr. Moietti said, and something I said earlier is confusion. You know, not everybody follows abortion laws and what's going on in the legal world as closely as people in this movement do. And what a lot of people hear is, oh, abortion's illegal, or maybe they're following someone on social media and they you know, and they see a post that says abortions after 6 weeks are not, you know, or just abortion in generally. Like with SB 8, we know that you can have an abortion in Texas before 6 weeks, but again, maybe what will be highlighted by the media would, oh, abortion ban in Texas, and then that is what will stick with a lot of people. So I feel like, and I know that we've seen this, our people just become less likely to reach out for help. So I think that's going to happen. Regardless of what the law is, what it actually states, what it means, I think is going to cause a lot of confusion, which is obviously intentional, and people are going to panic, and then people are not going to reach out for help like it is already happening with SB 8. So I think that's what we're going to continue to see, is people getting confused, people not knowing what to do. And then I will tell you this as an abortion storyteller and someone who's had 2 abortions: when you want an abortion, you will go to any length to have it. What I am afraid about is if someone feels that desperate and they're already convinced that abortion is illegal, I am afraid that someone may resort to an unsafe measure of having an abortion, because you can never ban, I mean, you can only make abortions illegal and unsafe, but you can't eliminate them. You know, they've been there since the beginning of time, and people will always need access to an abortion. I think back to myself, legal or not, I needed an abortion, and I would have figured out how to get one regardless of the consequences. So as Dr. Moietti told the story about a patient, I feel that I was in that place. I was in that very dark place, and I would have done whatever it took to have an abortion because I was not ready to be a parent. That is something that scares me. And it would be the fault of people causing all this confusion, enforcing these abortion bans, and coming up with all of these other ridiculous bans, confusion, and causing pain and suffering emotionally and physically to people that just are trying to access healthcare.
So we are typically conditioned to think about abortion as a question of gender justice and women's rights. But when the 2 of you testified for the House Committee on Oversight and Reform, what I thought was unusual about that event was that a number of the representatives were talking about race, and specifically the idea that abortion is tantamount to racial genocide. And they specifically identified the disproportionate rate of abortions within the African-American community as evidence of this particular argument. So can you speak a little bit about the sort of changing narrative around abortion? Why is there interest in reframing abortion as a racial injustice, linking abortion to eugenics, and why has it taken off in such a way at this moment?
I honestly don't know, because they could care the least about people of color, like the least. So why they all of a sudden are worried about.
Well, note that 4 of the people who mentioned this were among the 14 Republican congresspersons who voted against making Juneteenth a national holiday.
Exactly. So yeah, why now they care about racism and white supremacy and Black genocide, I'm completely at a loss for, right? I think what we do see, though, is often that the anti-abortion movement uses rhetoric from the abortion movement. And so I think that is part of it, that they're one of the best games that they're good at is saying fake things that mean the opposite, right? No Child Left Behind is like one of the best examples, but like they love using a fake term that means the opposite thing. And then I think that that's part of it, is that they take our language, repackage it into meaning essentially the opposite.
Yeah, I agree with that. And I also, they don't care. They don't care, but they'll use any excuse, they'll pick up on anything to try and, oh, look, we're the good ones and they're the bad ones. They will take anything. They truly do not care and do not believe in the cause. They do not care about Black lives. They don't do anything to support Black lives. It's just something that they're hijacking our narrative to kind of make themselves feel superior or make themselves, look like, oh, we actually care about this cause. I used to escort at one of the clinics, before the pandemic, and it would infuriate me because there was this one lady, anti-choice lady, who would hold a sign, and it made me so angry. She'd hold a sign that said Black babies' lives matter too. And it's the same people. These people don't care. These people don't care about racial justice. These people, they make racist comments, whether, they really don't care. And it just drives me crazy that all of the people that are protesting or yelling at people walking inside clinics are holding these signs, and I don't think there's a good answer. It's just they don't care, but they'll use anything and everything they have to just frame us as the worst people ever. So.
Yeah. And I think it's important for people to recognize that the anti-abortion movement is actually a integral part of the white supremacist movement in this country, and they are linked very closely. On January 6th, I was providing abortion care, and I drove into the clinic and thought, where the hell are all the protesters? And then as I was providing care, flipping through my phone, and I was like, oh, that's where they all are. And providers across the country actually saw their regular protesters on TV in DC. And so we have known for a long time in abortion care work across this country that they actually are hand in hand with white supremacist and white power movements. They have a long history together. They share information with each other, right? These movements are not separated. They are one and the same. And so it's fake. Their concern about Black people is completely fake.
I just want to add too, their concern about children is also pretty fake. It's the same people who are angry about our tax dollars going to provide school lunches for kids that are angry at people's, choice to have an abortion. So 100% fake. They don't care about children. They don't care about children of color.
So we've actually gotten a large number of questions, both in advance and during the program. So I just want to maybe frame some of these out for you and give you an opportunity. We have about 15 minutes left. What legal strategies and protections exist in the event that Roe does get overturned? What are we hoping could exist as in terms of protections? Julie, I know you mentioned the Women's Health Protection Act. This might be a good place to raise it again. So what exists currently that might be a backstop if Roe is overturned, and what is possible going forward?
I can start quickly, but I think two possibilities. One is definitely the Women's Health Protection Act, which would create, again, a statutory right to abortion access throughout the country, free from bans and all of the types of unnecessary restrictions that have made it hard for patients to access care and for people to provide the care. So that's something that Congress can do. In addition, of course, there are states, state constitutions, state statutes. So states can also take their own actions under their own law to protect abortion access. And I think that'll also be critical. So those are two things that I think are definitely possible on the legal front.
Would an equal rights amendment help, whether at the federal level or at the state level? And some states do have ERAs.
Yes, I think it's a tough question because some state ERAs have been interpreted to protect abortion access. And so I think it really varies in terms of what was the ERA designed to do. But of course, if the court overrules Roe, and Liz, I've got to believe I have a fighting chance here to preserve it. The people who care about this right, which is just such an incredibly important right for people to be able to make this decision for themselves, we won't stop fighting, bringing lawsuits. For years, of course, there have been arguments that equality would be a better basis for the right. And so there can both be constitutional arguments under the Equal Protection Clause, statutory arguments depending on the particular statute, but clearly this is an issue of equality as well as liberty. So, on the legal front, we will continue to do everything we can to protect people's ability to make this decision.
I think it's important just to also mention that I'm sure many of you know that whether we preserve Roe or not, Roe is not accessible for most people in our state prior to SB 8 even. And so for most of the country, Roe has never been enough. Roe it doesn't exist. And that is true for many of the communities I've taken care of over the past few years here. And so I hope we uphold Roe, and I hope that we move towards these other options, because we have been suffering in our state for quite a while, for several decades, actually. And, this ban is egregious, but so is every single other ban that we've had in this state.
When you say that Roe is effectively inaccessible or a nullity for many people throughout the country, are you speaking specifically of, Roe's protections are really about keeping the government out, not necessarily subsidizing or facilitating the conditions through which individuals can exercise the right?
Right. I think that's one component, right? That if you can't afford your abortion, that it doesn't matter if it's legal or not, but also that if you don't have a clinic in your neighborhood, if you don't have a safe place to go to get care, if you don't have, all of the pieces, and Roe doesn't protect any of those things, right? And so all of that, amounts to that right, that constitutional right, not actually being a right for many people in the communities that we take care of.
Go ahead. Sorry.
So I wanted to add one legal structure that does exist. It's in another area that I spend a lot of time thinking about, which has to do with law and religion. And there have obviously been a lot of objections to providing reproductive health care, but many providers, many institutions, many individuals have religious beliefs in favor of reproductive health care, including abortion, and many abortion providers are compelled by their conscience to provide abortion. So I think it is extremely important in that vein for abortion providers, people working in the reproductive justice field, institutions, to really think about writing down and developing their religious commitments to abortion, putting it in the record, maybe considering some corporate law changes that might reflect their religious identity or commitments, if that's part of the commitments of an institutional actor, because there is a increasingly robust constitutional framework for the protection of religious beliefs. Would these claims or defenses be successful? Maybe not, but they offer a plausible path to resist at least enforcement of such laws in specific cases, I think.
Well, that's a terrific segue to another question that a member of the audience has asked. Specifically, they've noted that so much of the history of abortion in this country has been imbued with questions of religion. And they noted that the pro-choice movement seems to have shied away from the question of religion over the last couple of years. So can you explain what you mean in terms of the expansion of claims of religious freedom and how this might work in favor of pro-choice arguments, and what the pro-choice movement overlooks in avoiding these questions of religion?
Yeah, I think largely, people in the pro-choice movement tend to be progressive. They don't want to impose their religious beliefs on others, which doesn't mean they don't hold those religious beliefs. Just in the past year, we've seen the Supreme Court seeming to shift toward greater protections for religion under constitutional law in a number of ways. So one, there's a real question of whether maybe strict scrutiny now applies. The Supreme Court in 1990 had said strict scrutiny no longer applies to generally applicable neutral laws that might impact religion. The Supreme Court may be moving away from that. The Supreme Court has also suggested that where a law has an exception, and laws often do, that it has to have an exception for religious objectors. So these are possibilities. I mean, in earlier cases, Hobby Lobby, for instance, allowed a corporation to exercise religion. Many abortion providers are organized in corporate form. And Hobby Lobby also said, you know, you have to show a substantial burden on religion, but a substantial burden is anything a religious believer says it is. And we're not going to inquire deeply into what a religious believer thinks. We don't require it to be rational. We don't require it to be consistent. We're seeing shades of this in the light and with regard to vaccines right now as well. So I think there are opportunities there to raise religion.
I
Okay.
wanted,
Sorry,
sorry,
go ahead.
I just
I didn't-
wanted to jump in about something. The faith part with, abortion at T-Fund, and I myself, I'm a person of faith, identify as Muslim. I'm spiritual and I believe. And yes, there's different religious beliefs of, is abortion okay? My religion has no conflict with the decision that I made. But as you said, I feel like sometimes talking about, religious exceptions can be a bit damaging, because I feel that it should have no impact whatsoever on someone's access to abortion. And when we start saying, but this religion's okay with it, and this is, it's interfering with my religious right, then I feel like it in some cases it can sort of, take access away from other people, because maybe a different faith doesn't feel the same way. And I think that's why some people in the pro-choice movement do, or a lot of people try to stay away from this conversation, because religion is irrelevant. Abortion is healthcare. And that's really the fact. Religion is irrelevant to healthcare. And I've personally had, when I was pregnant with my daughter, I've been abortion shamed. I've been abortion shamed by an OB. Thankfully, I switched to a different OB and I had a great experience. But there are providers who don't want to provide abortions because of their own religious beliefs, or even if they're not providing abortions, they'll shame you if you end up, unfortunately, with a doctor that has certain beliefs. So I really do think religion needs to be left out of the conversation. That's just how I feel.
Okay, so probably last big question, or last two questions. If Dobbs is decided in a minimalist way and Roe and Casey live to fight another day, what is the next challenge? What does that look like? Julie, what do you think?
Well, I have a lot of strong feelings about this. I mean, if you just give me one tiny bit of leeway, I think it's really hard to say that there's a minimalist way to decide this case. And I just think it's really critical to explain that to people. I know.
I don't mean minimalist like I just like, there's like the explosive, like overturning Roe, and then there's something else that is explosive, but maybe less.
I don't know what the other thing is what I'm trying to say. So one of the things I've heard people saying that I would love to dispel is this notion that the court will just apply the undue burden test to all restrictions and leave for another day to figure out, what happens, like you were saying earlier. But the thing is that the version of the undue burden test that the state is putting forward, that Mississippi is putting forward, is the same thing as no constitutional right at all. And I think it's critical for people to know that Mississippi is defending a 6-week ban with the same arguments that it's using to defend its 15-week ban. It wants to throw out the viability line. So what it uses the words undue burden, but what they're talking about bears no relationship to the court's jurisprudence.
Like, there is no burden that would be undue.
Well, exactly, because if a ban is not a burden, then nothing is a burden. And of course, that is Mississippi's point, because it also wants to uphold a 6-week ban. So I think what is really critical is for all of us who care about these issues to push on the fact that that is not any sort of middle ground. It is the same as overruling Roe. It means states can ban abortion at virtually any point in pregnancy. So what I would say is unclear to me is whether the court would actually set a different but earlier line that is stable and does provide some protection for abortion. So for instance, would it pick 12 weeks or 15 weeks or something like that and say that is a new line? I certainly don't want to predict the outcome in a case that I'm arguing. Folks have talked about that as a possibility. I don't know if it's a real possibility. That would provide some protection for abortion, but it would still be an overruling, and it would leave many, many people harmed, because we know that the people who need access to abortion after 12 or 15 weeks are often people in the most challenging circumstances. They couldn't get there earlier because of all the other restrictions and the logistical barriers. The fact that insurance coverage doesn't pay for abortion and they're trying to raise the funds and they have kids to take care of and need childcare. So I think, that to me is the question. So I'm sorry, I just have to say that I feel like, the claiming that the state's undue burden test is a middle ground is just wrong. So
Fair enough. I did want to just flag, though, that in addition to these challenges, to these bans at particular periods in gestation, there are also a number of quote unquote reason bans that have been percolating and are on cert, petition for cert at the court. Like one, for example, from the 8th Circuit prohibits abortion if it is undertaken for purposes of race selection, sex selection, or because of the diagnosis of a fetal abnormality. Another from Ohio, a 6th Circuit decision, would prohibit abortion if undertaken because of a diagnosis of Down syndrome. So again, these reason bans, I think, sort of tee up the whole question of eugenic abortion in a way that makes the race argument much more salient. And maybe the court would find that to be a more appealing vehicle for formally overruling Roe, because it allows racial injustice to sort of be the lead argument, as opposed to simply the question of what to do about Roe and the undue burden standard. Thoughts? Agree, disagree?
I don't even know what a race selection abortion is.
I mean, we should ask the Congress. They seem to know. It is kind of dystopic, but yes. And again, like, people have talked about the fact that these laws actually have a huge impact on communities of color who have more intrusive experiences with their healthcare providers because of the impact of these laws. Last question, about 5 minutes. Maybe we can do this as a round robin. One very intrepid audience member is headed home for Thanksgiving and wants to know, how do I talk to my family about SB 8 and Dobbs at the dinner table? So Aziza, why don't you kick us off? How would you talk to your family about these pressing issues at the Thanksgiving table?
I would say don't do it. Avoid it at all costs. No, well, like Malia said, my family is Muslim, so we don't have some of the same problems that I think other families that are sort of situated differently religiously and with different sort of commitments to conservative politics might have. And I just wanted to say one little thing, which is on that point that Professor Supper made about religion, which is that I think it does matter which religion you're kind of grounding your your claim for protection in, because Muslims are pretty sore losers, even though we have the ability to sort of potentially galvanize on the abortion issue. Kind of, we aren't winners at the Supreme Court. Yeah, I would say tread gently and try to keep the women who are really affected by this law front and center. These are poor women. They're women who need access to abortion for the most part. Of course, not everyone. Many of the women who are seeking access to abortion are women of color that may or may not have salience in a family discussion. I'm not sure, but these are the people whose lives really matter, and these are the people whose lives we're playing with, and we're playing out an entire constitutional battle, an entire ideological battle in a very concrete way on the bodies of people who need abortions, and it's harming people. And I think that's what we really should stay focused on.
Julie, how are you going to bring this up at Thanksgiving?
So my family's used to talking about these issues, so it's not a hard conversation for me. But I think, just really quickly, at the end of the day, what people need to think about is, if you're pregnant, if somebody is pregnant, who should be able to make the decision? Should it be the government, or should it be the person who's pregnant? And another way I like to put it is, what kind of world would we live in? What kind of society would we have if the government could decide when, if, and how many children a person should have instead of the person themselves? Does that make any sense?
You sound like you belong in the Federalist Society, Julie. It's very libertarian of you.
It just doesn't make any sense, right? That the government would be making those decisions. So I think that's critical for people to just be thinking about.
Hey, Liz, how are you going to talk about this on Thanksgiving evening?
I love what Julie just said. I think, there's an easy way and a hard way. I mean, I hesitate to adopt the easy way, which is, look, there have been a number of stories reported of people who are miscarrying, for instance, and have been turned away from the hospital due to SB 8. I hesitate to say bring up those stories, because it really focuses on the tip of the iceberg rather than the iceberg. On the other hand, you know, you have to gauge where your audience is ready to hear. You know, I think there's ways to personalize as well. Well, what would we have done if we lived in Texas and I got pregnant at 16? You know, I would have found out too late. What would we have done? And I think there are ways to have those kind of conversations and then maybe pivot to the libertarian point.
All right, Malia, how will you talk about this at the Thanksgiving table?
So being Pakistani, I didn't grow up during Thanksgiving. I'll be during Thanksgiving with my husband's family, and we're not politically aligned. Our families are not politically aligned. So I guess it's slightly harder. But I will say, I think when someone that cares about you, you know, everyone loves someone that's had an abortion. So it's this thing that we say, we testify, and it really is true. So I know that even though we don't necessarily share the same political leanings, you know, mine are very obvious, so you can only imagine. I think that when I've told my own story, because I've been very public about this with my own family, with my husband's family, and pretty much in other public spaces as well. I think that people that care about you for some reason tend to have a softer side, even though it's something, even if it's something they disagree with. So when it's someone that knows you, I feel like if you're able, and no one should have to do this under any pressure, but if it's an experience that you've had and you're willing and ready to be open about it, I think that sometimes family members can surprise you, even if they disagree with you. So that's where I leave it.
Dr. Moayedi, very quickly, how will you do this?
I always talk about abortion. I don't not talk about abortion. You can't hang out with me if we're not talking about abortion. So I'm going to be talking about it, but everyone knows. But I agree with Maliha. Everyone loves someone who's had an abortion. Most people spend a whole year or their lifetime never saying the word. So start with the word, just say it. Try saying it today. Have you said it today at all, right? Did you say abortion this week? And start you don't have to talk about the cases, just talk about abortion in general. Like just start talking about abortion.
All right. Thank you so much for joining us this afternoon. Thank you to our tremendous panel and our amazing co-sponsors, the Birnbaum Women's Leadership Network, the Journal of Law and Public Policy, and If, When, How. This has been a fantastic conversation and it will be available in a recording and transcription. Thanks so much for joining us.